So to answer what is case buildup, no? So it is a process in which prosecutors evaluate a complaint, no? And gather evidence to determine if there is a reasonable certainty of conviction for the crime. So in other words, it is the overall process that is being conducted by the prosecutor before arriving with a particular resolution, no? When the process might be involving these four procedures. So evaluation, no? The head of the prosecution office assesses the complaint and evidence. No? When we say assess, they are going to see if there is a prima facie evidence, no? Of or the quantum. They will assess the quantum of evidence, the quantum or the weight of the evidence. It involves also the notification or informing the complainant of the evaluation results and what evidence is needed. So if the evidences that was provided by the complainant is enough, no, and the prosecutor were able to evaluate it, no, so the prosecutor should inform the uh, involved party. But if the evidence is not enough, then the prosecutor should inform, no, the party that there is needed or there should be additional evidence that should be presented. So evidence collection is also involved in case build-up. The complainant secures and submit the requested evidence that is being asked by the prosecutor, no? Case termination if there is not enough evidence. So the prosecutor can terminate the case, but take note, the complainant can refile it later if there is already enough evidence, no, that they were able to discover. Okay, so on the authority to conduct preliminary investigation, now still our reference is on the DOJ Department Circular number 15, particularly stated in Rule number 3, Section number 6. So it mentions that all prosecutors that was mentioned under the RA 10071 or in the rules governing the practice or the prosecutors within the entire country. So that is the rule that governs them. RA 10071. No? So kung dati po ay meron pong judges that they can conduct a preliminary investigation, as we can see, wala po dito. It only mentions all prosecutors. The only difference is it is categorized, no, or it is organized. Bakit? No? So kung titignan po natin, no, dito ay meron po tayong tinatawag na state prosecutors, no, or the prosecutors assigned in the office of the Secretary of Justice or the office ni SOJ. So on the update, no, our current Secretary of Justice is Crispin Rimulya, no. So kung sino man daw yung mga prosecutors na naka-assign doon sa kanyang opisina, ito daw po yung pwede nilang gawin. Ano po ba daw yon, no? So they are the ones who can conduct preliminary investigation on cases involving national security or threat with our national security, such as terrorism, rebellion, no, that those might be, no, the state prosecutors or those prosecutors assigned in the office of the SOJ may conduct preliminary investigation over those cases. Aside from that, cases that involves or wherein task forces have been created, no? So task forces, or it involves different agency just to investigate that certain crime. Usually mga sensational crimes or those crimes na mabibigat, kumbaga, no? Just like task force between AFP and PNP, no? When it comes to kidnapping by terrorist groups, then that might be or the state prosecutors might have the authority to conduct preliminary investigation on those cases, or criminal cases which the venues were transferred to avoid miscarriage of justice. Take note of this. So venues that was transferred, that is conducted by the state prosecutor, or the PIA is conducted by the state prosecutor, or it depends also upon the order of the Secretary of Justice. No? If the Secretary of Justice sees that there is involved, no, or the public interest in involved with regards to that case, then he may order state prosecutors or state prosecutors assigned in his office to conduct preliminary investigation. Okay, so if those cases or crimes are not falling on those mentioned on this particular paragraph, then the city, the provincial or regional prosecutor may conduct or have the authority to conduct PI or inquest proceedings. So lahat po ng violations or offenses or crimes, no, cognizable by other proper courts, no, then they are being or preliminary investigation is being conducted by the city, provincial or regional prosecutor. Okay, so that is on this section. So what is the difference between preliminary investigation and virtual PI? No? So again, ito po yung sabi natin, or it may be referred as the regular preliminary investigation na sinasabi ng Department Circular number 28. So what is this so-called regular preliminary investigation, or just simply preliminary investigation defined in DOJ Department Circular number 15? So it is a summary proceeding. So it is summary in nature to determine whether a person should be indicted in the court after ascertaining, based on the evidence provided and after case build-up has been conducted, there is prima facie evidence. Kaya ito po yung sinabi natin kanina. Again, it is not only prima facie evidence, it should be with reasonable certainty of conviction, or for respondents conviction. So again, in the prosecution stage, tinatawag po natin ang ating or yung taong inakusahan natin as the respondent, no? So since there is a prima facie evidence, then the prosecutor may file the put the person in trial in court through filing an information in the court, no? So when we say virtual, again, it is the use of ICT, an abbreviation for information and communication technology, or as I've mentioned, simply the use of technology or the use of our gadgets such as cell phone, laptop with the internet, no, or the conduct of video conferencing or through online platforms. That is what we so-called as virtual preliminary investigation. So it is mentioning here that it may be availed at the initial hearing. So first that nag-meet po ang ating prosecutor and both parties, then they can agree if they can avail this so-called virtual preliminary investigation. So ano naman ang pagkakaiba ng inquest proceeding sa e-inquest, no? So inquest proceeding, it is an informal and summary investigation. Okay, informal, no? So kapag yung PI medyo formal kasi yun, no? Dito naman inquest proceeding, informal, no? And summary investigation conducted by prosecutor pa rin, no? And what is the main reason for inquest proceeding, no? Kapag daw yung tao ay naaresto, no, and detained without the benefit of a warrant of arrest, okay, then the prosecution may conduct an inquest proceeding, or ang tawag po dun sa gagawin nila ay inquest proceeding. Take note of that. Pag warrantless arrest yung tao, then or warrantless arrest or arrested without a warrant yung tao, then inquest proceeding. Okay? Now, Kapag e-inquest naman, simply parang po doon sa virtual preliminary investigation. So, simplified term for electronic, okay, or it stands for electronic. So, the conduct of inquest proceeding through video conferencing, okay, using appropriate or what is applicable na ICT or information communication technology. So, are the parties involved in the preliminary investigation? Siyempre, nandyan po ang complainant or the offended party. And then we have here also the respondent. Okay, so complainant, it is the one who filed a complaint affidavit, may be referring to the offended party or a law enforcer or a peace officer or the public officer charged with the enforcement of the law. Okay, and the respondent, we are referring to the party being charged with the commission of a crime or violation or an ordinance. Okay, so next. Okay, so what are the allowed affidavits to be filed or submitted during the preliminary investigation, as stated again in DC number 15, particularly in rule number 4, section 9. So, una po dyan ay complaint affidavit, no? So, it is a written statement charging a person with a crime, okay? Or simply, this is what we are mentioning as complaint, no? And now, kapag po yung ating respondent ay sinagot niya yung mga nilalaman ng complaint or sinagot ng ating respondent yung akusa na nilalaman or nakapaloob dun sa complaint affidavit, then we are calling it as counter affidavit. Okay, so it is a written statement of the respondent, no? So ito yung reply niya dun sa akusa nung complainant. Okay, so again, yung reply nung ating respondent on the complaint affidavit, counter affidavit. So that might be filed by the respondent during the conduct of preliminary investigation. Next, so kapag reply affidavit naman, ito ngayon yung response ni offended party or ni complainant, no? Or ni complainant on the counter affidavit of the respondent. Okay, so again, sabi natin kanina, no, nag-file si complainant ng complaint affidavit, and then ngayon nag-reply itong si respondent. So ang tawag natin doon sa reply niya ay sabi natin counter affidavit, no? So counter affidavit. And ngayon si na-receive ni complainant yung counter affidavit ni respondent, then ano naman yung pwede niyang i-submit? A reply affidavit, no? So the purpose is to answer those accusations or those counter statements ni respondent doon sa counter affidavit. Okay, and now the last affidavit that may be allowed to be submitted is the so-called rejoinder, no? So yung rejoinder naman, yan naman yung para kay para kay respondent. So ito naman yung reply ni respondent sa pinasa ni complainant na reply affidavit. Okay, so nagpasa si complainant ng reply affidavit and gustong sagutin ni respondent yung mga nilalaman or nakapaloob doon sa reply affidavit. Ang tawag po doon sa affidavit na ipapasa niya ay rejoinder affidavit. So response ni respondent doon sa sinabi ni complainant doon sa reply affidavit. Okay, so take note of this. So lahat po nito ay dapat under oath, no? So before acknowledging or in filing these affidavits, they are administered or they are taking or they should have an oath, or in the absence of an official who is authorized to administer an oath, then it may be availed or it may be, or it should be notarized by a notary public. Okay, so take note of this, no? So kung walang official that will administer an oath, no? Okay, then dyan daw pwede nating ang lapitan ay isang notary public. Okay, that is on this part.